Hello, everyone, and thank you for joining us today. We appreciate everyone taking the time to join us on navigating the H1B maze. I would like to welcome Anindita Chowdhury of USI Law. She's going to be providing the training to us. Anindita is the founder and managing attorney of USI Law, Inc. She comes to us with over 22 years of experience in immigration law. She obtained her Juris Doctorate from Washington College of Law, American University in Washington, D.C. She obtained her Master's of Art in Government from Lehigh University in Pennsylvania and her Bachelor of Art from Loreto College in Kolkata, India. She is a speaker at various immigration conferences around the world. She has strong connections on Capitol Hill and with the administration, and has attended and contributed to various policy and regulatory meetings. Her corporate clients include Global 1000 companies, mid-tier companies, and startups, which consist of IT, consulting, manufacturing, green technologies, oil and gas, mining, government contracting, professional services, and education. She also has significant experience with EB-5 investor visas to the United States. USI Law specializes in global corporate immigration with in-depth expertise in the full range of employment and immigration visas. USI Law offers strategic insight, guidance, and a results-oriented approach. Accountability is key to ensuring customer priorities are constantly met. The true value of USI Law lies in its employees, who each personify the willingness and desire to deliver the best for clients. They also provide immigration issue advocacy for clients through building of best-of-breeds coalitions. So now we're going to go ahead and get started. Again, thank you all for joining us. Just to give everybody a little bit of information, as we get started here today, everybody will remain on mute throughout the duration of the presentation, and it will be recorded. The recording will be available online by the end of this week. The presentation that Anindita is going to go through today during the training will be sent to you via email at the conclusion of today's presentation. If you have any questions, you can post them online using the GoToWebinar tool, and we will address those questions once she has completed her presentation. So thank you, Anindita, for joining us. I'm going to go ahead and let you get started.
Thank you, Christen, for your kind introduction. Good afternoon, good morning, depending on where we are in the time zone. Welcome, attendees. We at INSZoom are very excited, and at USI Law, that you were kind enough to make the time to discuss this very important visa, which encourages employment and professional immigration to the U.S. As we know, I just want to make sure that, Christen, you can see my screen, right? I just want to make sure.
Yes, I can. It looks fantastic.
Awesome. Awesome. Thank you, dear. The focus in what we do for a living and what all of us, if I can generalize, love doing every day for our clients, for our corporations that we work with, is essentially help them grow and change people's lives. At least that's my attitude towards what I do for a living every day. And immigration, as we know it, no matter what our focus is, whether it is corporate immigration, whether it's individual immigration for individuals, irrespective, it is all about putting the right people at the right place at the right time. And at USI Law, that is our main focus of what we do, for irrespective what the type of cases, the number of cases is per corporation. So it's all about working together as a team with the end client to deliver for the growth of the corporation and for the growth of this human being that is depending on us on a daily basis. I have the agenda open, so I want to quickly summarize on what we intend to cover in this session. And here we are looking at just an overview of primer and corporate immigration, an introduction to H1B visas. We will touch on H1B visas such as LCAs and public access files. Moving on, we can also dwell on what exactly should be included in a strong H1B petition, what composes a strong H1B petition. what is the definition of specialty occupation, which is what this visa is all about, and which particularly for all us practitioners in the last few years, I'm sure you'll agree with me when I say that the USCIS has been particularly strict about the next couple of bullets, which discusses specialty occupation and right to control ever since the new fill memo. We'll talk about H1B transfers. We'll talk about the Simeio policy memo, which is a big deal in today's H1B administration, relevant issues, and then, if we have time, like Christen said, we will also do an open discussion. Moving on to a slide that discusses corporate immigration. Irrespective of what you hear in the media, I think I don't need to tell any of you on the call that corporate immigration is definitely welcome in the U.S. And if I can, look at a crystal ball and predict for the future, it will continue to do so. It's immigration to the U.S. what makes U.S. one of the greatest countries that are on this earth today and will continue to be the same. Primarily, I think a significant contribution as far as percentage goes is immigration to the U.S. It has, as we all know, a worldwide welcome mat in comparison to any other country. For all of those of you who do global immigration, we can still say that the U.S. immigration and what the USCIS does for us on a daily basis is absolutely amazing. The government policies has, evolved or changed, but it does not take away from the fact that we are a nation of immigrants. And the greatest thing about this country is there is clear transparency as far as rules and regulations are concerned. Today, as we have discussed, H1B visas are our focus. What is an H visa? I want to just dwell on that for a few seconds. We have different categories of an H visa. What we'll discuss today is the H1B, which is the specialty occupation visa, which requires a minimum of a bachelor's degree. It is one of the options where if you want somebody to come here to professionally work in a position for a company, that would be one of the choices. H2A is temporary or seasonal agricultural worker, limited to citizens or nationals of designated countries. H2B is non-agricultural worker, again limited to citizens or nationals of designated countries. And H3 is a trainee or special education visitor. As we know, we're going to focus on the H1B. So H1B, the non-immigrant visa under the classification of Section 101A15H is basically called a visa that supports and is supported only by an offer of employment for a specialty occupation. What does a specialty occupation mean? A specialty occupation clearly is a position that is being offered by a petitioning company, which is US-based, for a position that requires a minimum for bachelor's degree. If you want the literal meaning of the word, the legal meaning as we have it on the slide, it's a theoretical and practical application of a body of highly specialized knowledge. It is limited to, as I mentioned, a petitioner, which is a company based out of the US, might have branches all around the world, but definitely there has to be a US employer requesting and petitioning for this visa on behalf of this foreign national, the prospective employee, for the fresh H's. We'll go into H transfers and extensions at a later slide. But irrespective of which type of H it is, for every petition that we file on behalf of a candidate, and the petitioner and our clients has to meet this threshold of specialty occupation. Whether it's a fresh, whether it's an extension, whether it's a transfer, irrespective, every time this test has to be met. The duration is a total of 6 years, but initially you can request for 3. There are some other avenues to extend the 6 years based on AC 21 regulations, but that goes into if there is a labor certification approved and an immigrant visa petition approved, then you can extend for another 3 years. If there's a labor certification or an immigrant visa petition pending for 365 days, that's another aspect of AC 21, Section 106. We'll get into that later, but essentially it is for technically a period of 6 years, but there are 2 exceptions where you can extend it further. Moving on to the quota system, which all of us are very familiar with, 65,000 visas are allocated on an immigration year basis, as we know that the immigration year starts October 1st and ends September 30th. So essentially, you can file for a visa 6 months prior to the start date. So in that way, for October 1st, it will be April 1st. When it is a fresh H for somebody who's never been on an H1B visa before, the quota is 65,000. It's all around the world. No preference to any country, no preference to any company. It's basically 65,000. And there is an additional provision, as we know, for 20,000 visas for students who have obtained a master's or higher degree, such as a PhD or others, from a U.S. university. So essentially, when you do the math, it's 65 plus 20, the 85. But if you're looking at somebody who does not have the master's or the higher degree from the U.S., it's pretty much 65,000 for the entire world. Okay, now what is the process that goes into the H1B? The H1B, before you can file the petition, you have to, on behalf of your client, conduct a prevailing wage, because the H1B is all about paying prevailing wage to this foreign national that the petitioner is petitioning for. So there is the Department of Labor's database that gives us the prevailing wage. This is determined by the county of the city and state of this where the job is located. And so we will have to first do the prevailing wage and then file for what we call the LCA, which is the labor condition application. This is an online application. 9035 is the form number, and it is filed with the U.S. Department of Labor. So basically, the Department of Labor is requiring the petitioner to document that they are paying the required wage for that job location or the geographic region where the job is located, and that the foreign national will make a minimum of that salary, if not higher. This is determined by the position title. Like I said, is determined by the county in where the job is located. And this is also determined by the seniority of the position. Typically, the DOL has this website where you can go from level 1 up to level 4. So depending on the years of experience, depending on the education that this candidate has, you will have to have an educated discussion with your petitioner, which is the company sponsoring the foreign national, to which level of this prevailing wage determination should you be going for. If the person has a master's and a PhD and 20 years of experience, it'll be very difficult to justify that that's a level 1 salary. So it depends on a combination of what the position is being offered to the foreign national and what the foreign national, what experience and education the foreign national is bringing to the table would be a compromise, and then the determination of the level of salary that should be fair to be paid for this foreign national. Once you submit the LCA to the DOL, as I told you, it's an online application. It takes approximately 4 to 5 days to process, business days. Okay? As I mentioned, H1B visas, the LCA at least to begin with, is location specific. It is also job specific. So hypothetically speaking, if your candidate, your employee, your foreign national has now gotten a promotion, guess what? You will have to do another LCA. And based on Simeio, which we'll go into in a few slides later, we will also have to do an entirely amended petition. So H1B visas, to state, are employer specific. What do I mean by that? So if the foreign national, Mr. So-and-so or Ms. So-and-so, is changing employers, it'll still be an H1B visa, but you will still have to file another petition. So therefore, it's employer specific, it's location specific, and it's job specific. Job specific means position specific. So to recap real quick, so if the employee moves to a new location, we will have to file an amended H. Earlier on, you could only file an LCA, but as of the Simeio regulations, you have to file an amended H if it is beyond 50 miles of the previous petition. Okay? And then again, when you file that H, like I mentioned, you will again have to go through the same test. You have to again determine the prevailing wage of that location. You will again have to file a new LCA based on that prevailing wage of the county and city and state where the new job is to be located, and then file the H accordingly. Like I mentioned, from a systems analyst, hypothetically in an IT setting, if the person gets promoted to a project manager after a few years, the promotion requires an amended H because it's a significant change in job duties, and an amended H has to be filed. There again, you will have to do the prevailing wage research. You will have to file another LCA and then file another H petition with the USCIS. There is a provision, which I just want to touch upon. H4 visas are visas for dependents. There's a spouse visas and children under the age of 21. They're considered dependents. So H4 visas are allocated to the non-H1B principal and can be obtained while the foreign national, if the person is coming from abroad, is applying for his or her own H1 visa. The spouse and the children can apply for their H4 visa at the U.S. consulate abroad at the same time. If they are in the U.S., you can file an extension for their H4 visas at the same time you file an extension for the H1. The rule is, or was, I would say, till a few months ago, that H4 visa holders would not be able to work. There was a lot of pressure, a lot of lobbying on Capitol Hill because L2s, which is a dependent of the L visa, were allowed to work based on AC-21. And the H4, it took us more than a decade and a half or almost 2 decades to get the H4 spouses to work. However, the H4 spouses don't have the same privileges as the L2, that they can come into the U.S. and then immediately apply for EAD, which is Employment Authorization Document. There's a limited opportunity, such as the H4 visa holder will be able to work provided an I-140 has been approved for the principal H1B visa holder, or if they are on their 7th year extension. So that's how you will get an H4 visa approval, employment authorization approval, sorry. Moving on, let us go back to the LCA. It's a very big deal to focus on the LCA, to understand what is so important to the U.S. government, to the DOL, Department of Labor, and therefore there are lots of investigations, there's lots of audits that go on with a lot of companies, as we all know, and that's becoming a thing of the times because the focus is this foreign national being paid a fair wage? Is this foreign national, being treated the same way a U.S. worker is, or being treated, should be? Is foreign national being treated as the U.S. worker is being treated in the same company? Or is there a difference? And to protect the foreign national against any such discrimination, they're very, very, very aggressive of upholding what is considered, the wage and hour division of the DOL is very aggressive in upholding these prevailing wage rules, which obviously come to fruition when the filing of an LCA. So what is an LCA? The LCA, like we mentioned, is a 1935 form. As a subset of the LCA, when you're creating an LCA, you have to create what is called a public access file. A public access file, surprisingly enough, in today's day and age of privacy, defies all rules of privacy. So a foreign national can walk off the street, walk into an HR office and say, you know what, I want to see the public access file of X or Y. And guess what? The company has to divulge or share the information. What goes into the creation of a public access file? It is the prevailing wage, which we talked about, basically a copy of the printout of the DOL's website of where you obtain the wage. What is the justification of the number that you put on the page 3 of the LCA? The LCA has to be posted for 10 consecutive business days. So confirmation of the posting. Normally, most law firms, most lawyers create a posting notice that your client just completes. Copy of the 1989 form, which has been certified. The actual wage memo, the wage rate statement, which is basically stating that, for this position, this is how much the company pays for similarly situated employees in the same position, and a summary of benefits. The summary of benefits, again, going back to the same essence of is the foreign national being availed of the same benefits that a U.S. employee can. The other focus of this is the foreign worker replacing U.S. employees for a lower salary? We know very well how much of that has come into scrutiny with the media. But my biggest frustration is with all the people who have an opinion about this, little do they know, or at least so it appears, of the prevailing wage rules. You cannot pay. I mean, if you're signing an LCA as a representative of the company, you are held to putting in writing and putting your signature beside a document that clearly says that the company is obligated to pay the prevailing wage to this foreign national. Okay? So as I mentioned, the LCA should be posted for two conspicuous locations of the job site for 10 consecutive business days. This is one issue which I know many of us come across. I mean, the job site for IT clients, as we know, most of them are actually at the end client, where the job is actually being performed. The requirement is that the LCA get posted at the job location, so which is not necessarily the headquarters of the company, but the job location at the end client. Moving on, bench pay, I want to spend a minute or two discussing this because it's a big deal. Most companies who are small, I guess, their logic is if the person is not assigned to a job, means the company, especially in the IT field, the company is not making money because the person is not allocated to an end client and they're not, generating revenue. The person, why do we have to pay that person? This is the biggest no-no, which I want you to communicate to all your clients, irrespective whether the person is actually working and generating revenue for the petitioner, or otherwise, where the project has ended and the person is just on bench, sitting at home, while the company should be finding the next project for him or her. The company is obligated to continue to paying that person the salary mentioned in the LCA and on the petition. So there's been a lot of audits. There's been a lot of fines because employees have brought this to the attention of the Wage and Hour Division at the DOL, and this has cost hundreds of thousands of dollars to many companies because they violated this. So I can't stress this enough that bench pay is a must for all H1B visa holders. And please, please, please communicate that to your clients. Moving on to withdrawal issues. Technically, I know a lot of our end clients, when there is a severance of relationship between the employee and the employer, there are clients who are like, you know what, we'll give them a 30-day grace period or a 45-day grace period or a 60-day grace period before we notify INS. I mean, you can only recommend to your client what to do. The client finally, has to make the decision. However, you should recommend that an H should be withdrawn, I would say within the same week that the termination was made effective. The foreign national must be educated about the fact that they're no longer a part of this company. And then essentially what goes into this is you will document, the HR will document that this person in an email or a letter, a termination letter, was notified the fact that he or she is no longer an employee of the company. Okay? And then my next step is for you to advise your client, the petitioner, to authorize you to withdraw the H visa. And this is writing a letter to the USCIS that has adjudicated the petition, attaching a copy of the 797, and basically informing them, guess what? Mr. So-and-so or Ms. So-and-so is no longer an employee of this company. And this will also help in a situation where there are companies, irrespective of size, small, middle, or large, a lot of people file petitions. So then for INS's record, this person is off the visa of this particular person. Okay? Now, in addition to that, the USCIS requires the petitioner to offer return transportation costs to the foreign national. Now, when it is by law, and there is the section on the I-129 that the petitioner actually signs, agreeing to offer this return transportation or pay for this return transportation. But what I have advised our clients is essentially the best way out is, offer to purchase a ticket for them. If in reality the person is returning to his or her home country, that they can pick it up at the airport when they check in. I will tell you, in my experience, of the thousands of cases we process, I think there might have been 1 or 2 that actually pick up this offer. The reason being, the H1B employee would have already found another employer to sponsor him or her and move on to continue the age extensions with another employer. If that is the case, you do not have to pay the fees. Moving on, what does an H1B petition include? We know if there's a law firm representing the petitioner, it will have the G28, the attorney representation form we are all familiar with. There is the I-129 and the H supplement. The I-129, as all of us know, is a 36-page form. The basic form is within, I would say, 8 pages. And then there are supplements which you add to, which are H-specific. So that comprises the I-129 form is a non-immigrant form which is used for several types of visas, H, L, O, Ps, et cetera, TNs. So you focus on just the pages that are required for the H1B visa. In addition to that, your application package must include a certified, which is an approved labor condition application. You cannot submit, for those of us who've been doing this for a little long period of time, in the good old days, if you were trying to beat a deadline, you could actually file an H petition with just an initiated LCA, but that's a thing of the past for quite a bit of time. So you can only submit the application with a certified labor condition application. Next is the very important support letter, which we will get into. Supporting documentation. I always want you to think, what we're trying to accomplish on behalf of the client? We talked about the specialty occupation, right? What does that mean? The specialty occupation is a two-way street. We need to prove on behalf of the petitioner, that is the company sponsoring the foreign national, that the position is a professional one which requires a minimum of a bachelor's degree. And the second half to the same argument to prove is to prove that the foreign national that they have selected to sponsor meets the criteria. How do you do that? You have the educational credentials of the foreign national. That could be diplomas and transcripts. If there are any professional certifications, please add that. In addition to that, you will attach at the bare minimum resume, experience letters from previous employers to prove that this person has the experience. Immigration-wise, if the person is outside the U.S., all you need to do is attach a passport copy of his passport or her passport. If the person is in the U.S., as we know, we will then need to prove that the person is in status. An extension of an H1B visa will it's a privilege, which will be extended to a foreign national, provided he or she can confirm and prove that they have status today. So how is that proven? Through a valid I-94 card and also a current pay stub. You will possibly not be able to get a letter from the HR of the company that you're quitting or moving on from to confirm that you're currently employed, obviously, because if you're severing ties, they're not going to be cooperating with you. So practice has determined that a pay stub that is less than 30 days is kind of an indicia of proof that the person is currently in status and should be enough to prove that for a transfer case. Okay? Educational evaluation. If the foreign national has degrees or only degrees that are from foreign universities, non-US universities, it is recommended to prepare a strong case that you must have the educational evaluation that is conducted by, there are several good educational evaluation companies in the market. Please approach them and then get an evaluation that must summarize or deduce that you have your candidate, the foreign national, has a minimum of a U.S. bachelor's degree. There are ways, if the person has a 3-year bachelor's degree, as some of us do know, in India specifically, there are some degrees, the BSc and the BA and the BCom are 3-year bachelor's degrees. So in that case, it will never be, just education alone will never be equivalent to what we consider as a 4-year bachelor's degree in the US. So there are combinations of where you can add professional experience, which is a ratio of 3 years to real life experience in the professional world is equivalent to 1 year in school. So you do a 3-year evaluation of the education, add 3 more years through the professional experience, and that will become 4 years equivalent to a bachelor's degree. And that your educational evaluator should work with you and, facilitate. Moving on, the support letter. At USI Law, we are of the big belief that in addition to all what we consider to be supporting documentation, the support letter is what makes and breaks your case. I have differing opinions of several practitioners across the industry on what should go in. That you will have to determine for your own firm, for your own comfort level. I'm not, going to tell you what to do, but I will tell you what we do at USI Law is we put in to this letter every possible thing in the best interest of our client to prove to the immigration officer, who's our audience, that this is a legitimate company, this is a legitimate offer of employment, this is a legitimate candidate who deserves the H1B visa. To that, there's a significant section about the petitioning organization to describe the business, to describe how long this business has been, existing, what they do. Then the next section is a job offered, which details the job title, the job duties, and how this foreign national, see how I go back to that specialty occupation, how this foreign national meets the criteria. Okay? Moving on to what is really become a bane of our existence, especially in any IT world, non-IT world, is the proof of the employee-employer relationship and the right to control. In all fairness to USCIS, I must say that when there was an IT boom, and there were thousands and thousands and thousands of petitions being filed, and the quota was being reached the first day in the good old days of 2007, 2008, and then now back to 2014, 2015, 2016, most of the visas, as we know, is eaten up by IT companies. IT companies, the way most of them function, okay, as we all know, is placement of professionals, qualified professionals at end client locations, which to an outsider appears like, oh, there are companies who just like dump this person at the end client site, have nothing to do with him or her other than just, making money. Let me put it very bluntly. That is not the essence of an H1B visa petition. The INS has made it very, very, very clear in the INA regulations that this is the petitioner, this is the employer, and there has to exist till the validity period or till this foreign national is employed with this employer, a very direct employee-employer relationship, and that the employer is the only person who controls the professional life of this foreign national, not the end client. And yes, there was a lot of misuse or abuse to the system, which then, the reaction of which was the new field memo. So we see, depending on how you prepare the petitions, there are RFEs some of us get, which basically hones in on that one issue, or two issues, I should say. Prove to me you're the employer. Prove to me this is your employee. Prove to me you have right to control. And prove to me how do you do this. I'm not just going to take your word for it. You prove to me how to go about documenting this right to control. Because the candidate might be sitting 200 miles, might be sitting 2,000 miles away from your headquarters where you claim you run your business. Then what control can an employer sitting in, Edison, New Jersey, have on somebody in Santa Clara, California, or in Tampa, Florida, or in Seattle, Washington? And that is how you build the case of, internally each company is different, that what checks and balances you have through the project manager, through the person on the ground at the end client, to control the daily operations, the weekly operations, the monthly operations. It's just not appraisal at once a year. So you really have to build the case with your client's help to document, and each company is different, right? So this employee-employer relationship and right to control is, in a sense, one of the strongest pillars that you have to build or help build with your client's help for your client. The second aspect is this itinerary of services. Okay, what is that? Most petitions, as we know, we can request for 3 years, right? So in the IT field, we also know that most of the MSAs and SOWs are as short as 3 months, as long as, at least the SOWs, as long as 12 months. The MSAs can go on for a few years. But how do you build the case for your client to prove that, you know what, company X wants to sponsor Mr. or Ms. So-and-so, but actually has worked for this candidate for the entire validity of the period that they are requesting for? And you will have to help your client build that based on whatever it is, they have the relationship with the end client, which again, is company specific and the relationship specific to the end client. Moving on to, in order to meet this specialty occupation, I think we've gone over this, but let's just, since we have a slide here, let me just delve into it just for a few seconds. We've talked about that the minimum requirements for the job is a bachelor's or higher. We'll also need to prove that this is a business necessity, meaning what? That it is typical for the industry to require this as a minimum requirement. So it's just not this company that has this weird requirement for this position. Everybody in the industry for this particular position does require this, and this is normal. So it's common in the industry why the person must require to have a bachelor's in whatever, computer science, engineering, whatever of the sort, for a systems analyst position or a program analyst position, if we touch upon the IT example. And that the employer normally requires this degree or its equivalent for this particular position. How do you prove that? You can show that in previous recruitment, non-H1B, maybe a U.S. citizen applied, this was also the position we required in that position for that advertisement. If you are nailed on the business necessity aspect of this position, which sometimes you are, specialty occupation business necessity, you can say, and you will have to document, that the specific duties of this particular position is so specialized and complex that the knowledge required to perform the duties is usually associated with the attainment of at least a bachelor's degree, if not higher. You have to build that argument for your client. This is a slide. I have gone into some of this, but we can quickly go through this. Goes back to the new field memo of employee-employer relationship. This is a typical bar that the USCIS requires us to meet when we present an H1B petition, no matter what the field is, no matter what the specialization is, no matter what the vertical of work is. So does the H1B supervise the does the petitioner, supervise the H1B employee or worker? Is the supervision off-site or on-site? If the supervision is off-site, how does the H1B maintain such supervision? This is what I had touched upon just a few seconds ago. Weekly calls. How does it report back to the main office? Is it a routine? What is the routine? Or does the project manager do some site visits? That's one way. Does the petitioner have the right to control to the work that the H1B is doing on a day-to-day basis, if such control is required? What did I tell you? The employer might be based in New Jersey, but the end client might be 2,000, 3,500 miles away. How do you prove as the employer that you still control the work of your employee? And as we also know, that in the IT world, there's a lot of subcontracting going on, right? That's the biggest other issue, where in which, company A might be the petitioner, company B might be the end client, but A is subcontracting to B, B is then subcontracting to C, and C is the one that holds the contract with the end client. But guess what? The foreign national is sitting at D. So how is A, who's 3 times removed from D, still controlling his or her employee? And that is what the INS is after, rightfully so, in my opinion. Moving on. Does the petitioner provide the tools or instrumentalities needed for the H1B worker to perform the job duties? Okay? Does the company provide the laptop? What instruments does the company provide to help this H1B worker that the company sponsored do the job? Does the petitioner hire, pay, and have the ability to fire the H1B employee? This, I would guess, in the relative terms, this is a shorter or easier one to answer. Does the petitioner evaluate the work product of the H1B worker? His or her progress, the performance. Does that reviewed other than just an annual review? Or the dangerous slippery slope is the employer has no clue because he's 2 or 3 times removed if the end client, and which is company D in my hypothetical, or company C, which has direct control of the employee. If that is the case, you are in trouble. Because the INS, rightfully so, will say, then you don't deserve the H1B worker, H1B visa for this worker. Company C should. Let company C petition for this worker. That's what we run into. Does the petitioner claim that the H-1B employee for tax purposes? That's a W-2 employee, kind of situation. Does the petitioner provide the H-1B for any type of employee benefits? Does the person get health benefits? Does the person get a 401k? These kinds of benefits actually help document that this beneficiary, the foreign national, is actually an employee of company A and not has minimal contact with B, C, and D. Number 9, does the H-1B employee use proprietary information of the petitioner in order to perform the job duties of this company, of this employment? Does the beneficiary produce an end product which is directly linked to the petitioner's line of business? This, as we know, at least in the IT world, for the most part, the end product that's being created is for company D and company D's best interest. But what control or contribution does company A have to this particular end product is what you need to prove. Last but not least on the slide, does the petitioner have the ability to control the manner and means in which the work product of the H-1B is accomplished? Moving on, portability. And we've touched upon the 2 bottom bullets, the last bullet, but we'll go over this now. Like I said, H-1B visas can be processed in 3 different categories. The 65,000 that we touched upon are primarily for fresh H's. For people who are not on H-1B visa, whether they're in the U.S. or outside the U.S. doesn't make a difference, and I mean most of them, it's easier to address if they're outside the U.S. But don't forget, there are F1 students who graduate, who get their OPTs, the optional practical training, 12 months if they're non-STEM, 29 or up to 44 months as we know if they're STEM, whatever. All of those are F1 students, which will fall under the cap. If you're an H4, a dependent spouse of an H-1B, and now you have a petitioner sponsoring you, you will also be a cap case. Just because you're an H4, that doesn't make you a part of the H-1B, not to be considered for the cap. You are not an H-1B visa. Anything other than an H-1B visa is cap subject. To talk about transfers, so if you are already on an H-1B visa and you're changing employers, that's where the transfer comes in. So you're changing employers, but guess what? You're still extending your H-1B. You can do so, and after the petition is filed and you have confirmation, if you want to go aggressive, if you have FedEx confirmation, that's one way to go. Or once the receipt comes in the mail in 5 to 7 days, as long as the U.S. Postal Service comes in, you are ready to start working for the new employer. If you're doing an extension, there's a 240-day rule, which basically says if a legitimate non-fraudulent application has been filed with the USCIS by this petitioner on behalf of this beneficiary, the work authorization is extended for 240 days. This is for an age extension with the same employer, okay? Not an age transfer. We know, and we touched base on the fact that the H is good for 6 years. There are exceptions, which we'll delve with just in a few seconds. However, if you have spent some time outside the U.S., earlier on you could not recapture vacation days. Now you can. So any time that you spent outside the U.S., you can recapture and add on to your 6-year max. The last bullet, which deals with AC-21, Section 104 we dealt with, which is basically you must have. For Section 104, you must have an approved labor cert and an approved I-140, and you come from a country that has a backlog. We know who those are very clearly. And you can apply for an age extension for 3 years at one go under Section 104. Section 106, same subsection of AC-21. If your labor cert or I-140 is pending for 365 days, then you can take advantage of Section 106, which will give you a 1-year extension. Most of these cases are audit cases. Moving on. There are cap-exempt H-1Bs, which do not fall under the 65,000 that we talked about, and that is for nonprofit organizations, higher education organizations, research organizations, government research organizations, et cetera, et cetera. In the interest of time, I'm going to just pick up my speed a little bit. Okay, The next slide, I hope you can see it, is the Simeio policy memo, which is the biggest news that happened as far as H1B visas are related as of 2015. There's a demarcation that has come on April 9th, 2015. This was something the INS, as we all know, snuck in right after it announced the age cap was reached. And I hope I can say this, most of us weren't even ready for this, weren't even looking for this, but essentially it's law. What is the law? The old rule was, if you're changing job locations, all you needed to do was file a new LCA with the DOL, post it in a new job location before the person started at the new job location, and then you were off the hook. You need not have filed an amendment. There were practitioners who were of the belief that you should still file a new amendment because the consulate was specifically asking, and I can say specifically in India, well, oh, did your employer file an amended petition before you started at this new client site? So depending on what your practice involved, you either filed the LCA and were content and, added that to the public access file and advised your client accordingly, or you filed an amended petition just to be safe, like 110%. However, as of April 9th, the USCIS memo clearly states that if you did not file an amended petition before April 9th, and in some cases, if you did not even file the LCA, and if you're not being investigated or audited, you might get away with not filing an amendment. Our advice at USI Law is don't take the chance, file an amendment. So the three lines in the way we look at this law is before April 9th, after April 9th, which is April 10th, through August 18th. And I say August 18th because as of August 19th, it became law that pretty much any change in work location, any change in job duties must file an amendment before the person moves to the work location. So there's a period in the middle between April 10th and August 18th where they're telling us that if you need to file an amendment, you must do so. Originally, the deadline was August 18th, and then they were kind enough, I'm sure there was pressure, and they were kind enough to extend it till Jan 15th. Okay? So the way I look at it is anything before August 18th, if you have not filed an amended petition, it is the safest to advise your client to do so. And anything August 19th onwards, please instruct your clients not to send the person to the work location before you have filed the amendment. We know the LCA takes 4 or 5 business days. If you have a blanket LCA, that's a different situation. But the petition takes at least a few business days to prepare. They will have to wait till you file the petition. INS acknowledges receipt, or FedEx or courier service acknowledges delivery if you want to be aggressive, and then the person flies into or travels to the end client location. However, January 15th is the deadline within which, August 19th, I must add, that if you do not comply with this new regulation, effective August 19th, your client will be considered in violation, or your company, the petitioner, will be considered in violation of the Simeio regulations and may be subject to investigation. January 15th is the deadline by which all amendments must be filed by petitioners, or else the company will be considered as a violator. Moving on, I want to focus on, and we've built on each one of these boxes through the course of this discussion we've had for almost 50 minutes now. What are the integral components to an H1B petition? And sometimes when INS feels that the petitioner, obviously with the assistance of counsel, if they have counsel, does not do a strong job, they're justified in generating an RFE. Well, we also know that even if you put everything in, there's still a chance that you'll get an RFE. That's the entire discussion in itself. But the components here we're looking at is, like we talked about, the employer-employee relationship, specialty occupation, proving that there is an itinerary of services for which the foreign national is required to do this job for this petitioner. Educational evaluation, we talked about if the person has foreign education, we need to prove that it's equivalent to a minimum of a bachelor's degree, US bachelor's degree. And then, if the person is going to be working at an end client, proof that the end client has work for this petition, for this foreign national. How do we do that? We can attach copies of the master service agreement. There are other project-related documentation that you can attach in the interest of proving that there is a relationship between company A and then company B, in my hypothetical. Most cases, if it is an ABCD hypothetical, you will not have direct relationship between A and D. You will have to work your darndest to establish contact between A and B, then work with B to see what you can do to show some end client contact to company D, or else you will have a weak case on your hands, as you know. One thing that we didn't touch upon is the in-house employment. There are companies, not everybody places them, at the end client. There are companies that have in-house employment where there is a team of people, there is facilities, there are space in the headquarters, there are floors and floors, and there are, computer terminals, et cetera, where the employees actually sit at the headquarters and work on in-house projects, maybe on products that the company develops. So if that is the case, there has to be adequate documentation to prove that this is what the foreign national is sitting at the headquarters and doing, and accordingly, prove that. Changing gears to the age cap. My advice is, since we have a hard deadline of filing everything, ideally on March 31st, I mean, each law firm, each practitioner has their own, evaluation, their own systems, but ideally, our 2 cents in the filing process is get a finalized list from your clients of all the cases, or most of the cases that you'll get by Jan 15th, start filing LCAs by Feb 1, then basically start preparing by Feb 15th, and then the cases have to be filed by, ideally, by March 31st. It is law, I'm sure most of you know, if not all of you know, it is law that you have 5 business days open. USCIS will be open for 5 business days to accept petitions. So even if the cap is reached the first day, that is not the end of the day you can file. So whatever the 5 business days are as per the calendar, which appears April 6, 2016, you will have till that period to file. Let us recap some of the FAQs real quick. The US, when can we start filing? We say March 31st because it can be only courier in. You cannot drop off your petitions in person. So April 1st is the first day to accept the 65,000 visas. Age portability we talked about, where a foreign national has a new employer. As soon as the USCIS receives the new transfer petition, technically the beneficiary is good to start. We talked about if you're already on an H1B and you want to move to a new employer, is the person cap subject? No. Is a person on an H4 EAD applying for H1B visa status cap subject? Yes. So that wraps up our presentation. And Christen, I'm open for questions. I know we have just a few minutes, but I'm good for questions at least for the next few minutes.
All right. Well, let me pull those up really quickly. We do have a few.
Okay.
Okay, the first question that we have is, given the fact that the position of law clerk has been discontinued, what position would you recommend for fresh law graduates awaiting the results of bar exams that would qualify as a specialty occupation?
The situation, I'll be honest with you, is kind of bleak because the practice of law requires a license. So if the bar license has not yet been administered to this applicant on or by March 31st, which is the date to file, or whatever, April 6th, let's just say, which is the date to file, making an argument, I mean, you could still file with the JD degree, but be ready for an RFE, which they will nail you down to prove that you had the license prior to the date of filing. Now, I mean, technically, if you have taken the July bar, or, well, February bar, it's too late. July bar, you should be barred by then, by March 31st. February, you won't even have your results. So depending on when you are getting barred, that would be a tough one to quantify and prove to the USCIS. that this position as an attorney, not a law clerk, requires the JD and a license to practice law, and that requirement has been met before you filed March 31st.
Okay. The next question is, if a current non-cap H-1B has a new job offer that is subject to cap, will that person still not be subject to the cap?
I'm assuming the person that we are referring to, the beneficiary, was in a non-cap situation, such as nonprofit and organizations, educational organizations. No, the person will be subject to a cap when you now apply for a cap subject position.
Okay.
So it will be a petition that will go into, and I can guarantee you this year also there will be another crazy lottery situation. I don't know whether it'll be crazier than last year. I foresee that, because not to delve into something that we've already had a session about, which is the L's, I happen to be at a presenter at the Zoom conference in October, and as you know, Christen, I shared with you that I did meet with the U.S. Chennai, blanket L visa team, and they've made it categorically clear that the USCIS memo, which deals with L's, have nothing to do with them, because it's a USCIS memo that was generated by DOJ. As far as they're concerned, it's DOS. And so they'll continue administering cases as is. So based on that, it's going to be, I think a crazier H1 cap year as far as filing goes.
Okay, thank you. The next question is, if a H-1B beneficiary has an I-140 approval, the spouse in H-4 is allowed to apply for employment authorization. If they have a dependent child that is of working age, is that child able to apply for employment authorization as well?
The answer that we have gotten is kind of gray as far as the USCIS is concerned, and we've gone through, attended a couple of sessions where this was asked, and they've always said that we need to consult amongst ourselves and get an answer. The answer so far is no.
Okay. Thank you. The next question is,
I don't know whether it will change in the foreseeable future, but right now it's no.
If we terminate the employee, until when do we need to pay the employee? If the employee asks about giving them the time to find another employer, are we liable to pay him during the time he's not working for us?
This is a very dangerous slope, and kindness will not get you to any place. I will assure you of that. Like I mentioned, that there are companies that say, oh, let's be kind. He might need or she might need 30 days or 45 days or 60 days. If you are not going to inform INS, and if you're not going to officially terminate the employee, which includes cutting off his pay, cutting off his benefits, severing ties as an employee-employer, guess what? You are on the hook. You are the employer, and yes, you're going to pay him till that period of time. Because as far as USAID is concerned, they know that this person is on your payroll based on that LCA and based on that H petition that you filed. So yes, you're responsible.
Okay.
So I would advise earlier than later. Unfortunately, I don't want to be harsh and nasty, but yes, for anything that will come back to haunt the petitioner, you better be safe, rather than sorry.
Okay. Next question, and we have 3 more. The next one is, in terms of cap exempt cases, if a high school has MOUs with universities/institutes of higher education, is that sufficient to support a cap exempt petition?
Cap exempt or otherwise, if I understand the question correctly, irrespective, when you're filing an H petition, you must meet the specialty occupation test. The specialty occupation test is twofold, as we discussed. One is the position being offered requires a bachelor's degree, and second is that the candidate being considered as the beneficiary must have the bachelor's degree. And if you have a high school degree, but then have 15 to 20 years of experience, what we do to the 3-to-1 ratio that we discussed, you take 12 years of the experience and then put it towards 4 years in school. That's the only way around it.
Okay. Thank you. The second to last question is, which H do you recommend for home health care providers? If a bachelor's is not required, an H2B?
Depends. I mean, that is a question we can take offline, and I can do, a little bit more research. But an H2B, as we know, is like, more for the seasonal aspect. I mean, depends on how long the help is necessary, what sort of a, petitioning organization it is. If that the person who's inquiring about that, if can give us a little more detail, Christen, you can channel that to us, and I can obviously help you a little more in detail about that. If a little more detail can be shared about the position and the petitioner, that would be helpful.
Okay. And the last question is, why can L2s come here and get employment authorization right away, and H4s have to wait until the H1B beneficiary has an approved I-140?
I could not agree with you more. I could not agree with you more. And this is what I told you, that, we've been in the business where, sitting in Washington, D.C., was involved partially, in the lobbying organization which created AC-21. But guess what? Capitalism at its best, the L1 got more attention than the H, because dependent spouses in H or L was something that was on the agenda going back to 15 years from now. And just now, this year is when we got lucky with the H4s, and that also, you're right, with these conditions. You have to have an employer who sponsors the principal. You have to have a green card that has gone through step number 2. Not everybody has that privilege, and it's just, in my opinion, unfair, but there's nothing you can do. Those are just the laws right now.
Okay. Thank you very much. We did receive one question that came in right after 3 o'clock, Anindita, so I will get that question to you along with the contact information for the person who posed it so you can respond. I would like to take this opportunity again to thank you for providing us with this excellent webinar and for our audience for joining us today.
Thank you very much for the opportunity, Christen, and I hope our listeners, our presentation was helpful. And if there's any person who has any follow-up questions, you're more than welcome to reach out to me. Thank you very much for the opportunity.
You're welcome. Thank you, everyone. Have a great day.